Good morning, students. So, today we are going to study about the contract, which is a unit of business law subject. So, first, what do you mean by contract? Or, how can you understand the word contract? To understand the word contract, we need to understand the word agreement first. So, the word agreement means every promise and every set of promise forming the consideration for each other. This definition is given by the Indian Contract Act 1872. On the basis of this, we can say that this is an agreement. And when can we say that this is a contract? According to the Indian Contract Act 1872 defines the contract under its section 2H as an agreement enforceable by law. Or in other words, you can say that a contract is anything that is an agreement and enforced by the law. So, there are three terms, that is promise, agreement, and contract. When you are promising, two terms are there under that. First, offer, and second, acceptance. Someone is offering you and you are accepting it. So, it will be a kind of promise. Second one is agreement. You're going to complete your promise by a contract promise, by signing or giving something in return. And the third one is contract. That is your agreement on that you will purchase the thing or any some kind of agreement you have made, plus enforcement by the law, which is legally done, or you are going to sign a papers so that you are having and the other party is having a proof that you are agreed and you are into a contract now. So, what do you mean by the word contract? The word contract was derived from the Latin word contractum. The word contractum means drawn together. The following are the definition with regards to the contract. The first definition is given by Salmond, that is, agreement creating and defining obligations between the parties is called contract. The second one is given by Plock. An agreement or promise enforceable at law is called contract. And the third one is Blackstone has given the definition of agreement, contract, agreement upon consideration basis to do or not to do a particular thing is called a contract. And the last definition given by Indian Contract Act 1872 section 2H. Agreement enforceable by the law is called contract. So these are some of the definitions given by some of the authors. So here is an example of agreement and contract and promise. So when you will say that it is a promise when someone is offering and you are accepting, that is promise. Suppose someone told you that there is a house and you want to purchase, then they have provided you the offer and you have accepted that you will go and see that house and you will verify. When you will say it is an agreement, when you are ready to do a legal formalities related to that object. And the last one, that is contract. The contract will be said only when you have completed all the legal things, all the legal formalities for that object, and that right now you are the owner of that object. At that time you can say that there is a contract between you and the other party. Thus, contract is defined as an agreement. To form an agreement, two elements are needed, namely, that is offer and acceptance. So, what is offer and what is acceptance in contract law? The status of offer is equal to that of question, and the status of acceptance is equal to that of answer. The person who is making the offer is called offerer or promiser or proposer. And the person who is giving acceptance is called a offeree or promisee or acceptor. Here is an example. A promises to buy B to sell his laptop for rupees 25,000 and B accepts to purchase it for the said amount. Here A and B entered into an agreement. So in the above example, you can say that A is a promiser and B is a promisee. So there are types of agreement. There are two types of agreement, or you can say that the classification of agreement is on the basis of two groups. That is social agreement and the another one is legal agreement. So what do you mean by social agreement? Social agreements are not enforceable because they do not create any legal obligations between the parties. For example, you can say that invitation for a dinner. You are inviting someone for the dinner, then it will be a social agreement because you are not going to follow any rules or regulation which is enforced by the law. It's your wish and is the other party wish whether they are ready to come or not. Or you can say you are organizing a party and you have invited someone. If they are coming, then they have accepted your offer. If they are not, then they have rejected your offer. The second one is legal agreement. Legal agreements are enforceable because they create a legal obligation between the parties. For example, A promised to sell his car to B. Over here, the legal obligations are that A promises and now he need to sell his car to B and B is going to pay money to A. So now we will discuss about the types of contract. So the contracts has been classified into three groups. The first one is on the basis of validity or enforceability. Second one on the basis of formation. The third one on the basis of performance. So under the first one on the basis of validity and enforceability, they have subdivided them into valid contract, void contract, voidable contract, illegal contract, and unforceable contract. On the basis of formation, they have subdivided that express contract, implied contract, quasi contract, and e contract. And the third one, that is on the basis of performance, they have subdivided that into executed contract and executory contract. Under executory contract, they have again subdivided into unilateral and bilateral contract. So now we will discuss it one by one. On the basis of validity. So under this, the first point is valid contract. When you can say that it is a valid contract, an agreement which is binding and enforceable is a valid contract. It contains all the essential elements of a valid contract. So all the essentials of a valid contract means there are some of the things that the paper should be ready, it should be acceptable, then the other party should be ready to purchase it, then there should not be any kind of force on the another party that you need to purchase it. These are some of the essential elements of a valid contract. Or it's his wish whether you want to purchase it or not. The second point is void contract. Under section 2J states the as follows. Contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Thus, void contract is one which cannot be enforced by the court of law. For example, you can say Mr. X agrees to write a book with the publisher. After a few days, X dies in an accident. So here the contract becomes void due to impossibility of performance of the contract. As Mr. X dies, so who's going to write the book? That's why the agreement became void. The second one is a contract with the B, who is the owner of a factory, for the supply of 50 tons of sugar. But before the supply is effected, the fire caught in the factory and everything was destroyed. So here again the agreement become or the contract become void because it was not finished, and because of fire the owner of the company or owner of the factory can't provide the 50 tons of sugar to the A. So it may be added by the way of clarification here that when a contract is void, it is not a contract at all. But the purpose of identifying it, it has to be called a void contract. The second next one is voidable contract. Under section 2I defines that an agreement which is enforceable by the law at the option of one or more parties thereto, but not at the option of the other or the others, is voidable contract. So in this fact means where one party is to the agreement is in position or is legally entailed or authorized to avoid performing his part, then the agreement is treated and becomes voidable. Such right might rise from the fact that contract may have been brought about by one of the parties by coercion, undue influence, fraud, or mispresentation, and hence the other party has the right to treat it as a voidable contract. Where one party fulfills his duties and the other party rejects to fulfill the duty, at that time you can say that it is a voidable contract and the other party need to be punished for that, or you can give a complaint against that party. The next one is illegal contract. It is a contract which the law forbids to be made. The court will not enforce such a contract but also the connected contracts. All illegal agreements are void, but all void agreements are not necessarily illegal. For example, you can say that a contract that is immoral or opposed to public policy are illegal in nature. Similarly, if R agrees with S to purchase brown sugar, it is an illegal agreement. If they are caught, then they will be punished because it is an illegal business. And this kind of contract is called illegal contracts. Over here you can see an example again. So one person is giving amount to another person saying that if you will kill my wife, I will provide you that much of money. This contract is void and initiative invalid from the very beginning as it is made for the illegal purpose. Unforceable contract. Where a contract is good in substance but because of some technical defects, that is absence in writing, barred by limitation, etc., one or the other parties cannot sue upon it. It is described as unforceable contract, where the papers are not correct or where the papers are not complete or he was failed to provide you all the kinds of information related to that object at that time, those kind of contracts are unforceable contracts. The second one is on the basis of formation of contract. So under that, the first one is express contracts, where you are explaining or where you are expressing your things in words or in the written format. A contract would be an express contract if the terms are expressed by the words or in writing. Section 9 of the Act provides that if the proposal or acceptance of any promise is made in words, the promise is said to be express. For example, you can see A tells to B on telephone that he offers to sell his house for rupees 4 lakhs, and B in reply informs A that he accepts the offer. This is an express contract where you are expressing that you want to do this thing, and if the other parties agreed, then those kind of contract are called express contract. Over here you can see the images that what two persons are talking, and the cloud is there, they are talking to each other and both are agreed. And the second one boy is giving a fence painting contract to a girl where he is ready to pay some amount after completing the project. So this kind of project they are giving, the boy is giving in return to a girl. Over here they both are just talking and making it verbally. The next one is implied contract. Implied contracts, in contrast, come into existence by implications. Most often, the implication is by law and or by the action. Section 9 of the Act contemplates such implied contracts when it lays down that insofar as such proposal or acceptance is made otherwise than in words, the promise is said to be implied. For example, you can see where a coolie is in a uniform picks up the luggage of A to be carried out of the railway station without being asked by A, and A allows him to do so. It is an implied contract, and A must pay the service for the service of the coolie detailed by him. So this is an example of implied. If over here the A rejects or he stops the coolie to take his items outside the railway station, then this won't be invalid or implied contract. The next one is tactic contract. Under tactic contract, there won't be any kind of sound or there won't be any kind of written things. There will be a judge who is making a count on who's going to bid for that product more. The word tactic means silent. Tactic contracts are those that are inferred through the conduct of parties without any word spoken or written. You can see the example over here. A classic example of tactic contract be when a cash is withdrawn by a customer of a bank from the automatic teller machine, that is ATM. So there won't be any kind of sound or there won't be any kind of written thing or any promises are made over there. So these kind of contract are called tactic contract. Another example of tactic contract is where a contract is assumed to have been entered when a sale is given effected to at the fall of hammer in an auction sale. It is not separated from the contract but falls within the scope of implied contract. You can see over here the one person is giving the hammer and there will be 3 counts. After that, that amount will be confirmed for that object. The next one is quasi contract. A quasi contract is not an actual contract but it is resembles a contract. It is created by law under certain circumstances. The law creates and enforces legal rights and obligations when no real contract exists. Such obligations are known as quasi contracts. In other words, it is a contract in which there is no intention on the part of either party to make the contract, but law imposes a contract upon the parties. You can see the example of quasi contract over here. Obligation of finder of lost goods to return them to the true owner, or liability of person to whom money is paid under mistake to repay it back, cannot be said to arise out of a contract, even it in its remote senses, as there is neither offer and nor acceptance or nor consent. These are said to be quasi contract. You can see the next contract, that is e contract. When a contract is entered into by two or more parties using electronic means such as emails, is known as e-commerce contracts. In electronic commerce, different parties persons create network which are linked to other networks through EDI, that is electronic data interchange. This helps in doing business transactions using electronic mode. These are known as EDI contracts or cyber contracts or mouse click contracts. You can see the example over here. These persons are giving the letter to each other, and the another person is signing it through digital. He is providing his digital signature for that contract. The third one and the last one, that is on the basis of performance of contract. Under this, the first one is executed contract. The consideration is given. Contract could be an act or forbearance. When the act is done or executed, or for the forbearance is brought on record, then the contract is executed contract. For example, when a grocer sells a sugar on cash payment, it is an executed contract because both the parties have done what they were to do under the contract. The purchaser want to purchase the sugar and the seller want to take the money. So both the parties have done their part. The second one is executory contract. In an executory contract, the consideration is reciprocal promise or obligation. Such consideration is to be performed in future only, and therefore these contracts are described as executory contracts. You can see the example where G agrees to take the tuition of H, a pre-engineering student, from the next month, and H is consideration promised to pay G rupees 1000 per month. The contract is executory because it is yet to be carried out, because they have just taken an agreement. It has not been converted into contract. When you can say it has been converted into the contract, when G agrees, when G takes the tuition and H pays the fees to G. So executory contract are subdivided into unilateral and bilateral. So we can understand the meaning by the name only. Uni means was single person. Unilateral contract is one side contract in which one party has performed his duty or obligations and the other party's obligation is outstanding, that he need to perform his duties. For example, you can say that M advertises payments of awards of rupees 3000 to anyone who finds his missing boy and brings him back. As soon as B traces the boy, there comes into existence an executed contract, because B so B has performed his obligation share of obligation, and it remains for M to pay the amount of reward to B. This type of executory contract is also called unilateral contract. The next one is bilateral contract. Over here the example is one is offerer and many are offerees. One need to pay and many came that we are having a boy to collect the amount. The next one is bilateral, where both the parties are liable to fulfill their duties. A bilateral contract is one where the obligation or the promise is outstanding on the part of both the parties. For example, A promises to sell his plot to B for rupees 1 lakh cash down, but B only pays only rupees 20,000 as earnest money and promises to pay the balance on next Sunday. On the other hand, A gives the possession of plot to B and promises to execute a sale deed on the receipt of the whole amount. The contract between A and B is executory because there remains something to be done on both the sides. Executory contracts are also known as bilateral contracts. So the contract will not be completed until they are fulfilling all the needs and details or the papers to complete the contract. Over here the example is one is offerer and another is offeree. There will be only two parties, that is one is selling and the another one is buying. The person who makes an offer, that is called offerer, and the person who to whom the contract was made, that is offeree. So there are some of the differences between a void contract and voidable contract. The first point is meaning. A void contract cannot be enforced at all, but a voidable contract is an agreement which is enforceable only at the option of one of the parties but not at the option of other party. The second one is definition. A contract ceases to be enforceable by law because void when it ceases to be enforceable under void contract, and under voidable contract an agreement which is enforceable by law at the option of one or more of the parties thereto but not for the option of the other or others is an voidable contract. The next one is performance of a contract. Void contract cannot be performed, but under unvoidable contract, if the aggrieved party does not fulfill the things at a reasonable time, then exercise his rights to avoid the contract. Any party can sue the other for claiming the performance of the contract. The next one is cause. A contract becomes void due to the change in the law or change in the circumstances beyond the contemplation of the parties. And under voidable contract, a contract becomes a voidable contract if the consent of the party was not free. And the last point is rights. Void contracts does not grant any rights to any party, but under voidable contract the parties whose consent was not free has the right to rescind the contract. So these are the some of the points between the void contract and voidable contract. So there are some other differences between void agreement and illegal agreement. The first point is scope. Void agreement is not necessarily illegal, and illegal agreement is always void. The second one is nature, for forbidden under the law, and under illegal agreement are forbidden under law. Void agreement are not forbidden and illegal agreement are forbidden under the law. The next one is punishment for the parties. Under void agreement, parties are not liable for any punishment under the law, but under illegal agreement, illegally agreements are liable for the punishment. The last one is collateral agreement. Under void agreements, it's not necessary that agreement collateral to void agreement may also be void, it may also be valid. But under illegal agreement, agreements collateral to illegal agreements are always void. So over here we complete our first topic, that is contract and agreement and the types of contracts.